Child, not me being mentioned. I wasn't ready for that today. Y'all ready to read the state's motion? I didn't even get through the other motion. I just did the video. Actually, I meant to put it out. I just did the video for the motions for a mistrial. And then we get another one from the state. I bet not be on the I bet not be. Don't summons me. No, let me get it ready so that we can read what exactly the state is requesting in this motion. I was supposed to upload the other video on YouTube. Yes, we are. This is Gen Pop. We are live because I wanted everybody to be a part of the conversation for this motion. So give me just a second. Oh shoot, because I wanted to post this. I wonder if it's going to work when I'm live. We'll see. I was posting the video again about the motion for a mistrial with double jeopardy attaching, which is what basically all except one of the attorneys who have filed a motion for a mistrial have all basically said that they want it to be with double jeopardy attaching. And the way that they are going about that, the way this is just a little prep before we get into this one, but basically they are saying that double jeopardy should be attached for that motion for a mistrial. And the reason that they are saying that is because according basically to the Supreme Court has held that if the prosecutors goad you, right, like bait you, do things intentionally that's going to make you file a motion for a mistrial so that they can get a do-over, if that happens, and obviously the defense can prove that to a judge, then it can be a mistrial with double jeopardy attached, meaning that they could not be retried. So that is what all of the attorneys are basically saying, that they had this ex parte on purpose because they knew that it was not allowed, and they wanted us to find out so that we would file a motion for a mistrial. And because they did that intentionally, this trial should be a mistrial should be granted and double jeopardy should attach, whereas the jurors have been sworn in and we cannot be retried. So that is what those motions for a mistrial are about. That is the video that I posted on TikTok, and I am posting right now to YouTube. But let's get to this one. There was a motion filed by the state, and it is a state's motion to restrict extrajudicial statements. So basically, the state is saying, hey, all of the defense attorneys are doing all of the I just want to go here. So the state is saying these attorneys, okay, all these folks are doing all these interviews, and we want the judge to step in and stop it. We want them to stop. So let's read what they say. Comes now, the state of Georgia moves this honorable court to instruct the defense to refrain from making further extrajudicial statements about this case moving forward. They cite the professional conduct rule 3.6 prohibits lawyers participating in litigation, meaning like in trial, from making extrajudicial statements a reasonable person would believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing and if the lawyer, where did I go? That it was prejudicing and proceeding in the matter. So basically, they don't want it to be they don't want the lawyer shouldn't be able to say stuff if they know that it's going to affect, is the word we'll choose, the proceeding. Amen. Let me go back. Let's keep going. A relevant factor in determining prejudice is the nature of the proceeding involved. Is the nature of the proceeding involved. I keep losing my spot. Oh, with criminal jury trials being the most sensitive to extrajudicial speech, the character, credibility, reputation of a party, and any opinion as to the guilt or innocence of a defendant the defendants are subjects deemed to be more likely to have a material prejudicial effect on a criminal proceeding. Defense counsel, okay, so now she's going kind of into the specifics. Defense counsel have made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated during the state's case in chief. Defendant Williams' counsel, attorney Brian Steele, he did an interview, and Keith Adams, defendant Kendrick's counsel, attorney Doug Weinstein, and defendant Steelwell's counsel, attorney Max Sharp, have all made extrajudicial statements to the media explicitly discussing this case in violation. So she's saying this is in violation of that rule that she just cited. The statements have included, among other things, interviews and statements to the Associated Press. Come on, am I press? Am I press? Hey, I'm not a lawyer being pressed. 4 of those interviews have been 25, 33, 43, and 107 minutes in length. The statements include, among other things, the attorney's views and opinions about the case itself, opposing counsel, the now former judge, the jury, the outcome, and the guilt or innocence of specific defendants. Pursuant to that rule, courts have the power to control in the furtherance of justice the conduct of its officers and other persons connected with judicial proceeding before it in every matter appertaining thereto. The state thus moves this honorable court to instruct the defense to refrain from making statements about this case moving forward. So she is essentially saying they have violated this rule 3.6 because they are not supposed to be in the middle of litigation. You are not supposed to be making statements if they're going to have a material effect about the case. That's essentially what that boils down to. And so then she gets into exhibits. And the exhibits, please find below. Oh, this is the Brian statement part regarding the recusal order. So Brian still made the statement, Jeffrey Williams is innocent of the charges brought in this indictment, and to clear his name, he sought a speedy trial, one of which he would receive the constitutional guarantees of a fair trial with an impartial judge presiding and ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Glanville from presiding over the case. We look forward to proceeding with a trial judge who will fairly and faithfully follow the law. So that was the one from Brian Steele, which she says he shouldn't have made, essentially. And then there is exhibit B, which is this interview. And there's the complete interview, 1512 minutes. 1512 through 55. So this is about 40-ish minutes. And then she has some excerpts noted. Let's see which one this is, though. Hold on. Let me see. So it's this one that was done with infamous Sylvia. And I just want to look at some of the excerpts that she says, 2309 to 2316. Let's see. 2309. Let's see what she said.
We don't need prosecutors doing unethical things and trying to trick the court or be dishonest to the court. We don't need that. We've certainly conducted ourselves in an ethical manner throughout the course of this trial, and that's all we want.
Okay, so that they have a problem with. And then 2336 through 2343. Oh, I think I can just keep playing this and let's see.
We want everything to be fair, and we firmly believe that if everything is done the way it's supposed to be done, if it's a fair, unbiased part of the trial, that Jeffrey Williams is going to walk out of that courtroom a free man. He's going to be exonerated of all of these things that he's been wrongly accused of.
All right, so that is the first one. Okay, the second one, Exhibit C. Exhibit C, the Associated, oh, this might be this. I wasn't the press, y'all. I wasn't the press. It was this. The Associated Press reached out to Glanville and to a lawyer for Young Thug seeking comment on Monday's ruling. A spokesperson for Fani Willis office declined to comment. And then apparently this comment came: while I respect Chief Judge Glanville and his service to this community and the country, he simply became biased over the course of this case. Kendrick's lawyer, Doug Weinstein, said in an email. He added that he looks forward to trying the case before an unbiased judge, but said the only outcome at this point is a mistrial and bond for Kendrick, who has been jailed for more than 2 years. So that is Exhibit C. Okay. And then we get to Exhibit D, which is an interview Doug Weinstein did with Megan Cuniff. Okay. And that one, let's look at the timestamps, 1511. So let's go to 1511. Right. Let's look at 1511.
As you said, I don't think any jury right now, even without us presenting any case at all, a jury could find RICO violations. A jury could find murder. Now they're in the middle of their murder case, but I don't think it gets any better for them.
No, and it's confusing. I mean, it's kind of just hard to follow. Like, what is their theory?
So there's a part of me for sure that says, I don't know if I want to restart this case from scratch, having allowed the prosecution 6 months to learn and give them a do-over.
Okay, and then the second one is from 1911. That is marked in the document. 1911. Let's see what he said.
I don't think their case is very good. Do they want to retry this? Do they want to indict it in a different way? I don't know what they're going to do. I really don't. That's something that's hard for me to predict. Like when we filed the motion to recuse, we had plans for all kinds of different outcomes, but I can't really plan based on trying to guess what the state may do if there's a mistrial.
Okay. So that is that exhibit. Now let's go to exhibit. Oh, it's another one. I won't play this one. It's another one. Exhibit E. That is an interview Megan the reporter with Max Shart. So he did another one, and she marks here 5235 through 5240. And then when you scroll a little further, you have Exhibit F. Does everyone see Exhibit F? Not YSL Mail. No, not YSL Mail. I'm not a lawyer, but the debrief interview with attorney Doug Weinstein. And there is a link there. Y'all, this is wild to me. Okay. This is wild. And there's a couple moments marked, not the whole interview being marked in. She wants the whole thing. Let's see what she has to say. 1012 through 1024. I want y'all to know this is it's funny the fact that this happened, but in real life, I'm like, keep me away from the courts. So like, hey, don't be mentioning me because I ain't got why am I in it? But no, let's see what she's saying was problematic or not even problematic, right? The whole point of the motion is that these attorneys are speaking about the case, about the judge, about the attorneys, the state, about what's happening. And that is really what her problem is. So these moments that she's called out apparently are marks in which he does so, according to her. So let's see.
I think at the present time, I think the trial's going very well for us. I think anyone that's been watching this can see that the state hasn't come close to proving any of the charges against Mr. Kendrick beyond a reasonable doubt. So it's not that the case is going bad. And if we're forced into a position of a mistrial, it won't be because we want one. It'll be because we've been goaded into one by the actions of the prosecutor in calling this ex parte hearing, by the actions of the judge in holding this ex parte hearing. But it's not a position that Mr. Kendrick wants to be in.
And that's essentially what he said in his motion. If I just made a video on the motion he filed today, and that is what he said in the motion, literally almost verbatim. The next one is 1550 through 1608. This is so funny to me. 1550. Okay.
The trial.
Yeah.
He's accused of serious crimes that he did not commit.
Mhm.
So to the extent that the public can watch what's going on and learn and see the case that the state thinks that they have against him. And of course, it's ultimately it's up to a jury to decide. But I'm more than happy to have the public watching this come to their own conclusions and see that Mr. Kendrick is not guilty of these crimes. So, yeah, I think, and I know that people view it for entertainment value. That's fine. I don't have a problem with that either. And I just, as a personal background, I mean, I spent 10 years in Asia working on.
I'll go to the next one, but I remember my question, which was, how do you feel about so much attention being put on this case? How people like me, who are not, traditional journalists and reporters and all of that, but like so many people are paying attention and making sure the public is aware of what's going on in this case. How do you feel about that? That is what he was answering. And low key, I think it's still a good question because we should know the things that are happening. So you trying to shut everything down, but in reality, I think that this kind of stuff is necessary and not necessary. She's not, I guess, saying it shouldn't be, but anyway, the next point is 618. Oh, I already passed the next marker, and then I'll go to the last one, 1856 through 1901. Let's see what he said at that point. Oh shoot,
Ollie and Anna.
I messed up, y'all. Hold on. 1856.
Good. This particular event that occurred is wonderful news because we've always felt that if we get a fair trial, we're going to get a not guilty verdict. And that's all we're looking for is a fair trial. Let's see the state present their case. To the extent we decide to, we'll put on our own case. And then Diamante can go home and he can start performing again and recording and doing all the things he loves and that people love about him.
Yeah. I love it. So that, ladies and gentlemen, is the mention of the debrief in, I should have shut that. Hello. The mention of the debrief in the motion, the state's motion. I'm going to read one of the other motions that came in today because I think it's interesting. But that essentially is the motion. If you haven't watched the full interview, go watch it because it's a good conversation that we had with Doug Weinstein. And then I'll answer just a couple questions too before I do this. That's funny how I got ads on my own video, right? I'm surprised she didn't pick on Attorney Bumbus. You know what? Because Attorney Bumbus's case, right, that show cause hearing was canceled essentially. The judge, what did he dismissed it essentially? There's no issue with her speaking on anything. So I believe that's probably why. Actually, did I go through all of them? There was no more. Okay, yeah. I wanted to make sure there was nothing left in that motion that I was missing, but that was pretty much it. State wants y'all to hush because they lose it. That's what the defense is saying. The defense is saying they want us that they have been losing, and that's really why they're trying to have a redo. Yeah, you gotta go watch the interview if you haven't before I get a summons, before they tell me I gotta take it down. Go watch it. That is so funny. I better not be in no more motions. I better not be. I don't want to be called to testify. I'm not a lawyer. Now I got to get a lawyer. I'm not. No. That's so, you guys are funny. Let me find the other one though. There was another motion that I wanted to read with you all. Y'all are funny. Yeah, shout out to Galactus. That went away, but I want to say thank you. Let me find it so I can properly thank you actually. Thank you. You are always supportive. I appreciate you. Thank you so much. I should tell y'all the different ones that are out right now in case you guys want to go through one in particular, or if you just want me to make the video, which is fine. So there is a motion. I think this one is Brian Steele put in a motion for bond for Jeffrey Williams, aka Young Thug, which is not surprising at all that he would be filing a motion for Jeffrey Williams and really all of them to get bond at this point. I think all of the attorneys have asked for that. Quamarvius Nichols, who is represented by Bruce Harvey, he also filed a motion for a mistrial. Let's see if his motion is any different. I imagine it's probably not. But let's read through that one. How many pages? It's only 7 pages, so it's not even that bad. Oh, since we're here, let's talk about him. Okay, so this is Quamarvius Nichols again, who's represented by Bruce Harvey. And so he says he adopts all the motions. So you guys have heard the Harvey rule, which is basically anytime a motion is filed or an objection is made in court, all the attorneys have said, hey, count us in, so that it's not like a bunch of, attorneys saying, hey, object. So everybody just gets to kind of pile in on that same one. And so he is saying Mr. Nichols adopts all motions and arguments for a mistrial as filed by co-defendants. So like by the one that was done by Doug Weinstein, as well as Max Sharp filed one as well, who represents Shannon Stillwell. If such motion, so he is saying if those motions are denied, Quamarvius Nichols further moves for a mistrial and objects to mid-trial substitution for the following reasons. I'm not sure what mid-trial substitution means yet, but let's read it and see. Mr. Nichols moves for a mistrial and objects to mid-trial substitution of the trial judge. Oh, so he is, okay, let me keep reading. Because here, for a judge to be substituted after 19 months of trial, including 6 months of testimony and the admission of evidence, prejudices the defendant's right to a fair trial under the 6th and 14th Amendments of the Constitution, as well as the, I'm not sure of that word, provisions of the Constitution of the state of Georgia. Further, Mr. Nichols moves for, so basically he's saying, the objection to a substitution is the judge. Like you shouldn't be able to just substitute the judge. Exactly. This Justice Matters comment, mid-trial change of the judge. He's objecting to that. Interesting. Let's keep going because that's interesting. Further, Mr. Nichols moves for mistrial and objects to mid-trial, okay? Because the current presiding judge was not the judge during the last, so basically, you ain't been here. How you get to come in right now? When, for example, Mr. Nichols moved for a directed verdict, this court will be unable to adequately evaluate the entirety of the prior proceedings in order to rule on the request. Okay. Of the 19 months of trial, over 6 months have been testimony for which this court was not present and therefore cannot base its decision based on what has occurred during trial. Basically, you haven't been here. So how can you, if I move for a mistrial, you don't even have enough information. You haven't been here. How do you get to properly rule as to if there should be a mistrial or not when you literally haven't been here? You don't know what's happened. That's what that is coming down to. Additionally, Mr. Nichols moves for a mistrial and objects to mid-trial substitution of the trial judge because on Friday, July 18th, this court advised the parties that she was unfamiliar with the previous trial proceedings that have occurred over the last year and a half. During the trial, before this court became the presiding court, Judge Glanville made several contingent decisions, noting that he would revisit his rulings as trial proceeded. These contingent rulings covered several aspects of the tentative admissibility of evidence. Given the fact that the current court is unfamiliar with over 6 months worth of testimony, arguments by the parties, motions by the parties, and contingent rulings, this court could not possibly make decisions based on what has occurred, which the court was not privy to, nor has reviewed the record. So if you recall, when the judge was, when they were in front of Judge Whitaker last week, she literally said, to be honest, I haven't been keeping up with this trial. I don't really know until right now. She, like, that wasn't verbatim quote, but that's essentially what she said. And he is saying, you haven't been keeping up. How do you come in? And he's also saying that Judge Glanville has said previously when they would raise issues or objections or whatever, he would say, we'll deal with that later. I'll revisit that later. And so now these earlier motions or contingent motions or, rulings were done such that Judge Glanville intended to revisit them at a later time. And now he can't revisit them because it's a new judge. And now this judge who's just coming in is just going to be coming in without proper background information and just going to be making a ruling. So he's really saying it's not fair. Yes, and the new judge did say she was not going to review. She said she wasn't going to review any of the prior things. She was basically like, I'm not going to go through all the stuff he already ruled on. I will do things going forward. And she was starting with Kenneth Copeland because he was still currently on the stand. And obviously all this was raised with him. So she was essentially starting there, but she was not going to go backwards. And that Bruce Harvey is saying that's a problem. Yeah, like exactly. That is a phrase that Max Sharp would say, which is the judge was kicking things down the road, kick the can down the road to revisit them later, but now he's gone. So now what? It's interesting. Further, Mr. Nichols moves for a mistrial and objects to the substitution. Because Nichols specifically on several occasions during trial moved the court to give curative Rule 105 instructions. And I can remember what that was, but let me keep reading. The court denied each request to give such instruction at the time, but indicated it may be necessary, I remember that though, to give it at a later time or at the end of trial. Mr. Nichols also moved the court for severance on multiple occasions. If you watch the trial live, I didn't always include these moments, but Bruce Harvey on multiple occasions asked to be severed. He would say, like, what is happening is going to prejudice the juror or my client. It's unfair to my client, and we want to be severed. We want to be separated from this trial. Let us have our own trial. We don't want to be a part of this mess. Bruce Harvey asked that multiple times, and the judge would continuously say no, deny it. Let me keep reading. Oh, so Rule 105, I had to look it up just before I finished. Rule 105 instruction. So what Bruce Harvey would ask is for a Rule 105 instruction, which is when evidence is admitted for one purpose or party, but it is inadmissible for another purpose or another party. So in a case where there are this many defendants, he would be saying, okay, you allowed this particular evidence in for this defendant, but it should be inadmissible against my client. So he was asking for the judge to basically instruct the jury that, hey, you can consider this, let's say, for Jeffrey Williams, but you can't consider it for Quamarvius Nichols. And the judge would say no. So that's what he's raising. Hopefully this is making sense. You guys are following. Let me keep reading. The court denied each request to give such instruction at the time, but indicated it may be necessary to give at a later time or at the end of trial. Mr. Nichols, okay, there we go, also moved for severance on multiple occasions, which the court denied at the time, but agreed that a time may come that the issue would be revisited. This court would now need the benefit of the 6 months worth of previous testimony to adequately and fairly make decisions regarding whether an instruction or a severance is warranted. Given the court is unfamiliar with the trial proceedings and has indicated that it did not intend on familiarizing itself with the trial's proceedings, the previous ones, which we know, Mr. Nichols' constitutional rights are violated because this court cannot make informed rulings based on the record. Trials evolve and decisions are made by the court based in part on the way trial and evidence play out over time. That is the truth. This court has missed crucial proceedings necessary to make fair and well-founded rulings and to properly instruct the jury both during and at the conclusion of trial. I don't know. I almost want to give you guys a poll because it's I'm not a lawyer, but these make sense. Like these arguments make sense. You know, that doesn't mean that the judge is going to agree and that it's enough for her to grant a mistrial, but there are good reasons. Nichols moves for mistrial and objects because this court has indicated that it does not intend on reviewing the complete record, including trial proceedings and litigation that have occurred. For this court to step into a 19-month ongoing trial in which over 100 witnesses have already testified means that this court is proceeding with trial and unable to assess core trial functions, such as the credibility of the witnesses that have already testified. The lack of a trial court being personally familiar with the record, but presiding over the continuation of this trial, making decisions regarding the trial, instructing the jury, violates Nichols' right to due process and a fair trial as guaranteed by our Constitution. That's what all these are always going to come down to at the end of the day. It's like a violation of a right to due process and a fair trial. Everybody has the right. And so All of these things they're saying are impeding upon that right. They violate it. Mr. Nichols further moves, okay, we know, because even if this court attempted to read the transcripts of the last 6 months, they would not be an adequate substitute for the court observing live testimony. So here's my recommendation. I'm going to motion that if Judge Whitaker needs to catch up on the last 19 months, I'm Not a Lawyer, but on TikTok has all the recaps, okay, with videos. Okay, if the concern is not being able to watch it live, I got the recap. I have enough for her. She can watch my whole playlist and be caught up in time to preside. I'm just saying. Let me keep going. That's a little plug. Even if this court attempted to, he gonna play me right here. Even if this court attempted to watch 6 months of trial proceedings via media recordings from afar or from my videos, that would not be an adequate substitute for the court's personal and direct observations. If there was an argument to the contrary, Nichols notes that the media was not allowed to film several witnesses and at times were not recording due to technical difficulties. Okay, so he kind of just like... he just killed my argument, but like I made a good argument. How about the very next sentence was him saying, "No, girl, nobody's watching your video." Okay, let me keep going. Nichols moves. Okay. Because trial has been suspended for over a month. I didn't realize he's just like listing out reasons. This is interesting. Because trial has been suspended for over a month and jurors cannot reasonably be expected to just pick up where they left off with their memories and observations intact. Furthermore, a mid-trial substituted judge cannot adequately instruct the jury regarding previous proceedings, which the judge is unfamiliar with. I tell you what, I had an interview with Kayla Bumpus, if you're not aware, it's on my YouTube as well. And the thing she said that will forever be interesting is when court resumes, if it were to resume with this same jury, and there's now a new judge, what do you say? What could a judge possibly say to this jury that is going to make sense? Especially if they're going to say something to this jury and then be like, by the way, in addition to that, everything you saw and heard from Kenneth Copeland, the last witness from June 12th, forget all that. That would only, we are all the people who would be called as jurors. So if somebody told you that the judge is gone and they're telling you now to forget everything that the last witness said, would you not go home and Google? I would be like, let me turn off my Alexa now. Hey, Alexa, what happened in YSL? Hey, Siri, what happened? I would, girl, so quick. So it's like, how do you just pick up? Sorry, I'm on a tangent. Let me keep reading. Oh, this is the last one. Further, Nichols reiterates and realleges his request for a severance. So he's still asking for a severance and incorporates his previous arguments that an enormous amount of prejudicial spillover has already occurred and no jury could be expected to compartmentalize the evidence as it relates to the separate defendants and charges. So this is respectfully by Bruce Harvey and Nicole Westmoreland, who I think is amazing. So there you go. That is that one. Let me find the others, because I'm telling you, there's been a lot today filed. I got the station motion too. This one is interesting. Let's read this one because I wonder how many pages. Oh, it's only 5 pages. I'm not sure what this one completely is yet, but let's read it because I'm really curious. Let me look at some comments before I keep going too. They probably already Googled stuff. And imagine, even if they haven't Googled, you got family. If my sister, brother, husband, child was like missing every day for a long time and if I didn't know, and all of a sudden they're on break and I know that YSL is on break and then I would be like, you a juror, ain't it? You saw what happened. I would casually be in the next room talking about it so they can hear me. Like, it feels unrealistic. It feels unrealistic to expect these jurors to have no idea. And I don't understand how you continue knowing that. Listen, if we're over here spazzing out, I know she is probably like, what were y'all doing? This is not what I signed up for. Yeah. Now let me read a little bit. She probably knew this was coming. She said it has to be turned in by Friday at 5. And all the attorneys at 4:55 were like, send. Oh my goodness. I read it. That's how I started. I started this live. If you are just joining, I started this live with exhibit. What number was it? Exhibit F in the motion to make the defendant's attorney stop talking. I started off reading that one because my podcast and my interview with Doug Weinstein was referenced there. So if you're just joining, that's where we started. And feel free to look at it. Okay, let me read this one because it says exclude victim bad character evidence, which my understanding, if you just read it, victim, which would be Donovan Thomas, to exclude bad character evidence, I'm assuming to exclude like talking about the kind of person he was because he is a victim. That's what I believe this is for, but we should read it. Which is also very interesting because excluding, if let's say, I'm not saying this is the case, if let's say the character of somebody, it has to do with the reason that they were unalived, like if somebody, unalived them, killed them, based on that, it's interesting that you can file a motion to like exclude the bad character evidence. But let's read it because I don't know. First of all, I'm not a lawyer, but not to the stand. I'm not going to the stand. If I do, I'm calling everybody in the Patreon is coming too. Let's read it. Hold on. Okay, so state's motion to exclude victim character evidence. The state believes the defendants in the above styled case, obviously the defendants here, may attempt to improperly place the character of the deceased victim, Mr. Donovan Thomas Jr., in issue at the trial of this case. For the reasons stated below, the state moves this court to prohibit any attempt by defendants to elicit and introduce improper character evidence as prohibited, and then she gives a code. Defendants Diamante Kendrick and Shannon Stillwell are charged in count 2 with the January 10th, 2015 murder of Donovan Thomas Jr., overt acts 16 through 20 of count 1, conspiracy, blah, blah, blah. Also pertain to the murder of Donovan Thomas Jr., the defendants have pled not guilty to both count 1 and 2 and have never raised or asserted any claim of self-defense. If I need, don't make me answer. For context, I just included this in my video, but if you need the context, the RICO, right, consists of the first count is for RICO, it's for violating the RICO Act, but all of the other counts are more specific. And so the second count is a murder, it's for murder, and it is for the murder of Donovan Thomas Jr. And Shannon Stillwell, as well as Diamante Kendrick, as well as 2 other people, are charged with that specific count, with murder. So that is what she just kind of explained. Hold on, let me read this one. Mel, invite Love to the debrief. She's feeling left out. Everybody getting interviews except her. I think she's jealous. I actually I would not be opposed to interviewing Miss Hilton. I don't necessarily want to interview Attorney Love, but I would entertain. Look at me saying I would entertain. I would need her to entertain being interviewed because I'm curious. Okay, so Georgia evidentiary statutes govern admissibility of a victim's character. These statutes generally limit evidence of a victim's, so those particular laws generally limit evidence of a victim's character to reputation or opinion and not specific bad acts. Okay, this code or statute provides in pertinent part as follows. Evidence of a person's character or a trait of character shall not be admissible for the purpose of proving action in conformity therewith on a particular occasion. There are 3 enumerated exceptions. 1, pertinent trait of character offered by a party to rebut the same, evidence of the victim's character trait for peacefulness to rebut evidence that the victim was the initial aggressor, evidence of the character of a witness. Where evidence of a character or trait of a person is admissible, proof shall be made by testimony as to reputation or by testimony in the form of an opinion. So we'll keep reading for the breakdown of what exactly she's saying. Generally, a murder victim's character is irrelevant and inadmissible. Okay, so generally, if somebody is killed, you can't talk about the kind of person they are because the crime is the murder, not necessarily the kind of person they are. A victim's character may only be admitted if there exists some factual nexus to the conclusion for which it is being offered. So, unless you're able to prove that there is a connection to their character and the reason they were killed, which is essentially what I was just saying, it is impermissible to establish such a nexus through sheer speculation. You cannot speculate, it has to be factual. Even if cases where an accused is arguing self-defense, okay, so even if you were saying, I killed him out of self-defense, the accused may only seek to introduce evidence of the victim's violent character through the admission of reputation and opinion testimony. So the character of Donovan Thomas is irrelevant and inadmissible in this trial because there's no factual nexus for introducing any evidence pertaining to his character. Furthermore, any evidence of the victim's violent character is unequivocally irrelevant because no defendant has claimed self-defense. Finally, even if the court were to find a relevant purpose for victim character evidence, it could only permit admission through reputation and opinion, not specific acts. Okay, so the state requests this court to prohibit. So she is almost like preemptively, it hasn't been done yet, but she is saying, should the defense attempt to bring in evidence that talks about the character of Donovan Thomas, she is saying it should be excluded. Again, almost preemptively, because I'm not sure that they have requested that. But that essentially is her motion. That was quick, actually. I thought it was going to be longer. Okay. Let's see which other ones I'm missing. Oh, I want to read this one. I think this is a Max Shart one, which I don't think I've read a Max Shart one. So let me read some of what y'all are saying first. Attorney Hilton's interview would be 2 weeks long. Have you seen the way she questions and talks? Oh man. Yeah, first of all, shout out to y'all. If you're just joining, I was reading the mention of I'm not a lawyer, but the debrief and the state's motion to basically make the defendants and their attorneys, well, not the defendants, they're not really talking, but make the defense attorneys stop doing interviews. That's where we started. But now I'm just going through, there's a ton of motions that have been filed today. So I'm going through some of those motions so that we can catch up on what has been filed today. So let me go to this one filed by Shannon Stillwell. Filed by Max Shart on behalf of Shannon Stillwell. I really would love to talk to Max Shart, but I mean, I guess that may not happen if the judge grants this. Motion for reconsiderations regarding certain hearsay statements. So, okay. Mr. Stillwell is accused of multiple felonies, including count 1, conspiracy to violate RICO. We know that. And specific substantive felonies. Mr. Stillwell is innocent of all charges against him. He is also, as I was just saying, charged with the January 10th alleged murder of Donovan Thomas and count 2, which we, again, just went over. Kenneth Copeland is a witness called by the state. Kenneth Copeland, a witness called by the state, is currently on the stand. Mr. Copeland has never claimed to have any firsthand knowledge regarding the death of Donovan Thomas. Mr. Copeland did, however, meet with law enforcement several times in 2015. On June 10th, 2015, in what Copeland's 5th meeting with law enforcement in 2015, Copeland told law enforcement that he possessed specific information so on that date, Kenneth Copeland tells the police that he possessed specific information regarding the shooting death of Donovan Thomas. Mr. Copeland made this claim while under the threat of arrest for unrelated crimes that law enforcement was investigating. Copeland did not mention this information on any of the 4 prior meetings with law enforcement. And this is in June that this happened. And if you remember, Donovan Thomas was killed in January 10th. So this is 6 months later. And he's saying he met with him all this time. And in June, when he is being threatened with being arrested for something unrelated, is when he finally is like, actually, I got information about Donovan Thomas's murder. In his June interview, Kenneth Copeland told law enforcement that he picked up Demikian Garlington at a McDonald's restaurant on the evening of January 10th. Copeland reported that Garlington walked to his car, and while the 2 men were briefly alone, Garlington told Copeland that they, which is in quotations, killed Nutt. Copeland told law enforcement that Garlington then pointed to a group of people who were pulling into the McDonald's. Copeland told law enforcement that he interpreted Garlington's words and actions to mean that, I'm assuming the people in the car and also the people charged with this, Mr. Stillwell, Mr. Kendricks, Justin Cobb, and Demise McMullen, were all present for and all participated in a drive-by shooting of Donovan Thomas. Per Copeland, Demise McMullen entered his car, shortly after that, and all communication about the event ceased. Okay, I get where he's going with this. Mr. Copeland is now a sworn witness. On direct examination thus far, Copeland has not denied making this statement to law enforcement. But he's basically said, I'm a liar. Copeland testified at trial that this conversation never occurred. Oh, so now he's saying we actually never talked, and that he, Kenneth Copeland, lied about it to get himself out of legal trouble. Further, Copeland has denied contextual clues surrounding the out-of-court statement, testifying that if it was Mr. Stillwell and not Mr. McMullen who got in the car with him and Garlington that evening. I was going to say on the stand, he said Shannon got in the car with him. But in this, I guess in that interview, he said McMullen got in the car. Stillwell has challenged the admissibility of, okay, so this is where it comes down to the hearsay part. Stillwell has challenged the admissibility of Garlington's out-of-court statements on hearsay and confrontation clause grounds. Judge Glanville, who has since been recused from this case, ruled that the statements were admissible as statements of a co-conspirator. So when you are, who else is charged in this? So Stillwell is charged. And so because it is a co-conspirator, there is and sometimes hearsay can be admitted through a co-conspirator. And that's why the Judge Glanville allowed it. But this ruling does not comport with the U.S. Constitution or the Georgia Rules of Evidence. It requires only that the proponent of the evidence establish the existence of the conspiracy and show that the statement was made during the pendency of the conspiracy, but that the proponent must also establish that the statement was made in furtherance, of the conspiracy. So assuming that Garlington actually said what he said to Copeland, these statements were not made in furtherance of the conspiracy. It wouldn't be in furtherance. It would have been after it already happened. To find otherwise simply overlooks, disregards the plain language. So you're ignoring basically the actual statute and allowing this, but that's not what it says. And the line of controlling cases that establish that statement that spills the beans by definition does not further a conspiracy. Hopefully that is making sense. He's basically saying the judge allowed so here's what it comes down to. Kenneth Copeland told police what somebody else told him. And that makes it hearsay. Kenneth Copeland was not there for the alleged murder of Donovan Thomas. So he is only telling police what he says one of them told him. And so because of that, they don't have the ability to cross-examine the person who actually said it, right? And so if Demikian Garlington is the person who told Kenneth Copeland that, the defense has the right to cross-examine Demikian Garlington about what he said. And so that's why he's saying we don't get to cross-examine him, and that's unfair. This should not be admissible. And the reason that the state is saying that it should be admissible, they're actually interpreting that law incorrectly, is what they're saying. Hopefully you guys are following. Okay. And agreeing. A lot of, you know what the problem is, which if you've been watching, you know, a lot of this trial has come down to hearsay. There's never really been much of someone actually being there who's able to get on the stand and who has said it before and at this moment in time are still saying it. That really hasn't happened. It's been a ton of hearsay, a ton of people on the phone who said, "Oh my God, they told me," and so they're playing the jail call, but it's what somebody else told them. It's not actual firsthand knowledge, and that becomes the problem. The state plans to elicit testimony from Kenneth Copeland regarding Garlington's alleged statement. So he's planning to ask Kenneth Copeland about whatever he's saying Kenneth Copeland told him. While Copeland is now denying that Garlington made any such statements, Copeland has openly acknowledged that he previously told law enforcement that Garlington made said statements. The state has attempted to improperly introduce the contents of Garlington's statements through recordings of Copeland. So they're trying to get these hearsay statements in by playing what Kenneth Copeland previously said to police. The state's method is improper for two reasons. First, Kenneth Copeland has denied making these statements and therefore has no foundation for prior inconsistent statements has not denied. Oh, first, Kenneth Copeland has not denied making these prior statements and therefore no foundation for prior inconsistent statements has been laid. So if Kenneth Copeland is on the stand and you're like, did you tell police that Demekion Garlington told you that they killed Nut? And if he says, I don't recall, that's not a prior inconsistent statement. He's just saying, I don't recall. Inconsistent would be, no, I didn't say that. Okay, that's not let me play what you said, because that would be, I'm challenging your inconsistency. But Shart is saying that's not what happened. And so they are now trying to play these tapes, but you're not it's not a prior inconsistent statement. Okay, and then the second, which is the focus of the motion, Garlington's statements to Copeland, even if uttered, were not made in furtherance of the conspiracy and therefore failed to meet the requirements. So again, he didn't say it like, yo, let's go kill Nut. What he is alleging was said was they did it. It would be after the case. So that's not in furtherance of a conspiracy. It would be after the conspiracy. Yeah. Well, and that's why I don't recall, I don't remember are different than no, that didn't happen. Yeah. I don't understand why so much is dependent on what his testimony. He told us he lied. You know what the problem is? So much is dependent on his testimony because so much this case was built on what he said happened. And so they being the state, can't afford for him not to get on there and all of a sudden change his mind. This is so important. And this goes to why they are saying that they were goaded into this mistrial, the defense saying they were goaded into this mistrial, because if the state is losing, is what they're saying, is what the defense is saying. If the state is like, shoot, our star witness is now not gonna say what we need him, we done messed up. We got to refigure this out. So that's why they're saying they were goaded into filing for a mistrial. Yeah. And the state, he is now saying, I lied, but the state is saying, no, you were telling the truth back then. And that's why also at one point, the state was trying to say, when you made those statements back then, you weren't in front of all your friends or the people who used to be your friends. And now you're in front of all the people who used to be your friends. And now all of a sudden you didn't change your story. You were telling the truth then, but now you're lying in front of them because you're scared of them, essentially. Yeah, he is the state's key star witness. He is who much of this case was built on. The way that they were connecting these pieces and the reasons why and the motivation and much of it was based off of these interviews that he gave. Attorneys do interviews all the time. Is she out of her mind? They do be on the news. And Trump be on the news for that matter. So I think that was Max Sharts. That was Max Sharts. I don't think I'm missing. There were some, again, ones for a bond because these men have been locked up for 2 years. And so now there's some for a bond. But I think that that essentially was the motions that were filed. So let me just make sure. Bond, mistrial. We already know that there was some motions to disqualify the prosecutors. Obviously they want to strike Attorney Love and Woody's testimony. I'm just making sure I'm not missing anything. I think that was it. He can make or break this case, and we all know what he doing to the case, breaking it out. I need new Young Thug music anyway. I have seen some of his interviews. And you know what? The thing that I like about some of the interviews is that I like when you can see the humanity of people, right? I like when people are presented one way because it is a trial, it is court, it is a case. This is a big deal. These are very serious matters. He is, being locked up. Like all of that, right, will make you get on the stand and act crazy. And so, an interview in which you can see him as a person, I always appreciate things like that, interviews like that, the humanity of people, and you can be reminded that these people are people. So yes, I have seen some. But to this point, I don't know if you get on the stand and say I'm a liar, I don't know where you go from there. And if you are, that's the other thing. I'm a little bit of a tangent now, but imagine being in the judge's chambers with the state and the judge. That is an intimidating and very scary situation. Like I would be like, oh my gosh, this is the judge. These are the prosecutors. There's investigator. There's all these people. And if all the focus is about my testimony, it could start to feel like I'm being forced to testify. Like that would be intimidating. It would be terrifying. As a regular person, I would be terrified. At what point will who be, I'm probably way behind on comments, but I'm not sure who you mean. At what point will they be called to testify? Meaning the the prosecutors and the judge? Brian Steele has added it to his witness list. So if this trial were to continue and the state finishes their presentation of their case and the defense gets to present their case, when it's Steele's turn, he will call them up. Is what he's saying. I do agree with this. This is why all court proceedings should have media coverage. I think that we should all be able to witness this kind of stuff. We should all be familiar with and understand our rights, what can happen when who knew about an ex parte before this YSL case? Like, had anybody, even if you are a true crimer, had you heard about ex parte and understood what it was and that it was not okay? Like, you would all be new to that. But now, based off of this case, and it's been everywhere, we are all legal experts now. I'm not a lawyer, but I might be, because I can tell you about an ex parte. Let me keep going. And that is the other thing. This stuff is from so long ago. And I should balance that because this stuff is from so long ago, but it don't matter when you lost your loved one, like that matters, right? And so I agree that it is a long time ago, but obviously there are victims. And so that's why it should be done fairly. Trials should be fairly. If you can fairly prosecute these people, okay, do so, and okay, put them in jail. But if you have to be sneaky and be violating rights, like that's not what we should be doing. At what point will I be called to testify? I'm finna lead the country. I'm just kidding. I hope the state ain't. Don't be watching this video, state. Don't cite. I don't want to be in no more exhibits. Look at this. No clue about ex parte. Nope, didn't know. Wait, the only reason I have is because I'm a criminal. Okay, let me get you off the comments here. Look, we all are. Star Chambers, we know all the lingo. We in there. Oh, you knew. I was not aware. I didn't know what a ex parte. I had to call my little judge friend to be like, hey, explain this to me. I know I couldn't be a lawyer. Too much research involved. Y'all hilarious. Okay. So I'm not leaving the country. I'm literally just kidding. I'm wondering what the RICO has to do with the murder trials. So the way that, right, it's a RICO, which indicates an organization, right? The RICO is that there's an organization of people, i.e. more than one person, who are conspiring to violate this act. So within, that's the first count. But so everybody in the RICO is charged with count one. Everybody is a part of being a gang, essentially. Well, violating the RICO Act, because it's not illegal to be a gang, but obviously violating the RICO. So everybody is a part of that. Not the problem. Within that, though, there are these different acts that kind of count up to their violation of the RICO Act. And so the murder of Donovan Thomas, they're saying, was a part of to benefit the organization YSL. I don't even know if that's what you were asking, but I hope so. So, but my point is, within this trial, they are proving all the different counts. There are a bunch of counts. And so within this, in order to prove the RICO, they're proving all these other counts are the actions that kind of led up to it as well. Let me keep going. Yes, we are, all of y'all are co-conspirators. Now I'm ready to go to court. Come on, all the criminal justice majors. We all in here lawyers now, okay? Once the trial starts back, where can you watch live? Honestly, there's a bunch of Atlanta news stations that stream it. Fox 11 or something. There's channel 11 or something, and then there's a 5, and then Law and Crime also stream it. So you can stream it live on YouTube. A bunch of different channels all play it. So you can watch it on YouTube live. They'll be back on Tuesday, the 30th, and that will be streamed. If you watch the debrief or are a member of Patreon, you know Terrence Cox right here. He helps book our guests so there's been some amazing guests. Make sure you check out the debrief. He helps book. He didn't book Doug Weinstein. I booked Doug Weinstein myself. Oh, hold on. Here's 5 towards your action, Jackson. Thank you. I'm gonna need it, apparently. Obviously, court cases are free. If you got time, you can go to the courthouse and sit in on a couple. You can't have your phone and your laptop and your electronics, but you can sit there with a notepad and a pen and go watch if you choose to. Yeah. Fox 5, these are people. That's how behind I am in these comments. If you wanted to watch the trial, just put Fox 5 or put YSL trial on YouTube. I just know pro se because I'm always representing myself. Not you representing yourself at trial, child. What you be doing? Thank you. Thank you. If you learn anything from my videos and enjoy them, I appreciate it. Thank you. Y'all the best. Appreciate you. When Thug gets out, Atlanta gonna go crazy. I can't wait. I'm gonna make sure I'm not there because that's gonna be crazy. What else y'all talking about? I do want to interview Alan Jacks. Oops. Well, yes, to this, obviously join, but that's not the comment I was trying to get. I would love to interview, obviously, Alan Jackson from the Karen Reed trial. Are you ever going to make a trip? I actually am planning potentially to be in Atlanta this weekend and up until Tuesday. So if that happens, I do intend to go to the trial on Tuesday when they are back and they're going through the motions. If my schedule permits and allows and I go to Atlanta like I'm intending to, then my goal is to go to the courthouse and to be in the room on Tuesday. So look out for the video on Tuesday. You'll see if I actually win or not. Mel, I got a subpoena. I was told to give you, Drew. You can keep it. I moved. Let me get you off the screen. They'll be back in court on the 30th, and it is to rule on the motions. And she said, she being Judge Whitaker, said that they are going to start and they intend to go for most of the day. And that is going to be the schedule for Tuesday, Wednesday, Thursday, Friday. She is planning to go through all of the motions. That's why she wanted them all to be turned in today, all motions. And then the state has to respond and the defense, if the defense wants to respond like to that motion about Donovan Thomas and his character, or if they wanted to respond to the motion about being on the debrief, they have to respond by Friday. The state and the defense have to respond to the motions by Friday. And then on Tuesday, they'll start oral arguments, if she's even going to make them argue, or if she's going to have read through them all and she'll just start kind of making rulings. Thank you. What exactly has Love and Hilton done for Brian Steele filed the motion to get them recused off the case? The ex parte. Because he essentially is saying, you are now witnesses that I intend to call. So you can't be a witness in this case and be a prosecutor. So because of the ex parte, he filed the motion to have them recused. A lot of people, I also love Lawyer, you know, he's obviously a real lawyer and he knows a ton. So shout out to him. Yeah, that's why I'm not sure if I'm going to make it to Atlanta, is because Delta being crazy. If I walk into that courtroom, what if I get a side eye? I'm going to be like, I'm not a lawyer, but don't be side-eyeing me. Oh, that's why I should be there, right? So that when she's presenting and I need to be in the room when she's like, look at this interview. I could be like, objection, Your Honor. I'm just talking, y'all. It's hilarious. Let me go through the rest of these so I can get off of here. Y'all can have y'all day back. Fly Southwest if you can. And listen, I won't, if I make it, I will not be late. I will be on time. Listen, if y'all see me on the Law and Crime Live at the podium, I'm gonna be like Brian Steele. I need to be in the same holding cell as Thug, as my client, so we can talk about it. I'm kidding. I'm really kidding. If I were to be called, I would freak out. Oh my goodness. Yes. If you are new to my content and are not aware, I covered the entire YNW Melly case from last year. That was one of the first cases that I covered that really got a lot of attention on TikTok. When that case comes back, I will be covering it again. That is a wild case. If you're not aware, you should do a catch up from my playlist. I will be covering that. All right, let me scroll. Oh my gosh, I'm so behind. Okay. If defendants are considered innocent until proven guilty, how is it fair to keep them locked up for the duration of the trial, especially when it's a link? That is the question. right? Like when you start having people locked up for years and yet you're saying innocent until proven guilty, like how does that line up? The problem is, right, what really goes into a judge's decision about bond, right, is like your criminal history, the severity of the crime you're accused of. It's like your access to resources, stuff like that, right, goes into a judge's decision on keeping you in jail or allowing you to get out. But I think this is a core question that so many of us have, which is if you're innocent until proven guilty, how could you then be held? It makes no sense. So yeah, it's a good point. Wave at the DA. Love it. Say, hey girl. I'm not doing that with you, Galactus. Sorry. Remember when you started and people used to comment on your video saying, girl, hush, you giving the state's evidence? When I started doing YNW Melly, I got so many comments like, you the ops, you giving the state's evidence. And now I'm an exhibit in the now I'm in a whole exhibit. Anyway, I ain't got no warrants, I promise. I promise. I wouldn't even show up. I ain't got no warrants, I promise. Anyway, all right, I just went through all the motions. I am posting a full recap of the motion for a mistrial with that Weinstein filed, and all the other attorneys kind of double down on it. Mistrial with double jeopardy attached. I think it's a very interesting argument. I cannot wait to hear what the judge says in response specifically to that motion, because I think that there are a lot of support for that. So watch that video if you haven't. Rewatch this one if you want to see the shout out in the motion, Exhibit F for the state's motion. I'm going to go live with the Patreon right now. We're going to do a little Q&A, talk a little bit longer before I get off of here for the day. So if you're in Patreon, look out for the link. If you're not in Patreon, want to join the conversation, come join. And if I do go to Atlanta next week, I'll probably go live with Patreon too. So all the more reason for you to tap in, because we have a good time over there. All right, y'all. Thank y'all for watching and joining. We were 600 strong in here. All right. Bye. And I'm gonna close my closet door.